Welcome back, everybody, to the Law of the European Union. The previous few lessons had been taking a brief introduction to some of the basic concept of the European Union, looking at the historical development, looking at the process of joining the European Union, and then finally ending on the process of leaving the European Union. This lesson is going to introduce the next of our major topics, which looks at the institutions of the European Union, as well as the process of lawmaking within EU law specifically. In this first lesson examining the institutions of the European Union, what we're going to do is spend some time looking at the different structural components and parts of the EU from what I've described here as something of a generalist perspective. And the idea here is to take an overview of the various institutions of the Union as a way of being able to then start to unpack these institutions in more detail as time goes on in future lessons. So, ultimately, the European Union began arguably with the Treaty of Rome and the European Economic Community back in 1958, and was a relatively small collection of institutions. It then grew into a number of collective institutions, all of which have their own functions, purposes, and powers. And it is the purpose of this series of lessons, this second chapter, to talk about the collective institutions in their detail and to talk about the various different functions and powers that each of them have and the ways in which they contribute to the creation of not only policy within the European Union but also EU law. The different institutions of the European Union, I apologise, are defined and outlined specifically in Article 13 on the Treaty on European Union. And Article 13 of the TEU says the following. It says that the Union shall have an institutional framework which shall aim to promote its values, advance its objectives, serve its interests, those of its citizens and those of the member states, and ensure the consistency, effectiveness, and continuity of its policies and actions. The Union institutions shall be, and then it starts to list the Union institutions, and they are listed as follows: the European Parliament, the European Council, the European Commission, hereafter referred to as the Commission, the Court of Justice of the European Union, the European Central Bank, the European Court of Auditors. So, a couple of things to note straight away. You have two different councils within the European Union. Interestingly, there are actually three different councils in Europe because the Council of Europe, being a separate institution, also exists. But sometimes you can refer to the council as the Council of the European Union. Sometimes it is better described in that way. So you have the European Council, and then you have the Council of the European Union, which are two different institutions. The Court of Justice of the European Union also has its own subsidiary court structure as well, which we will get to when we talk about the ECJ in more detail. The European Commission is often referred to as just the Commission, given that there is only one of them. And then the two final institutions on this list are not going to be covered in this series of lessons because they're not necessarily too relevant, only for when we talk about European financial law and the way in which European monetary law operates, will we talk about the European Central Bank. But for the most part, we're going to talk about the Parliament, the Council of the European Council, the Council, Commission, and the ECJ in more detail. Part 2 of Article 13 says that each institution shall act within the limits of the powers conferred to it in the treaties, and in conformity with the procedures, conditions, and objectives set out in them. The institution shall practice mutual sincere cooperation. We will get to what sincere cooperation means in the future, but Part 3 says that the provisions relating to the European Central Bank and the Court of Auditors and detailed provisions on other institutions are set out in the treaty on the functioning of the European Union. The European Parliament, the Council, and the Commission shall be assisted by the Economic and Social Committee as well as the Committee of the Regions, acting in an advisory capacity. So, essentially what this means is that when we go to looking at each of the institutions individually, when we do a lesson, for example, on the European Parliament on its own, we're going to have to then go and jump to the Treaty on the Functioning of the European Union to outline the competences, the powers, and the procedures that exist within the European Parliament and the Council and the European Council, etc., etc. Now, I want to finish this introductory lesson by just discussing briefly the importance of the European institutions. because arguably students of EU law ought to be really and most familiar with these three institutions: the Parliament, the Council of Ministers, and the European Commission. When it comes to the process of making EU law, the lawmaking process itself, as we will see as time goes on, these institutions are incredibly important for our understanding. Law students will also have to be incredibly familiar with the Court of Justice for the European Union, sometimes described as the CJEU, or sometimes just described as the ECJ. Often we go for the former rather than the latter these days, because it is actually formally described as the Court of Justice of the European Union, rather than just the European Court of Justice. This is where we're going to find the majority of our case law on the matter of the European Union. And so, for the most part, these are the four institutions that we're going to have a lot of time and spend a lot of time examining in more detail.